Char, I will let you begin.
Okay, very good. Thank you very much. So, as I discussed earlier, there have been a number of bipartisan proposals for a federal data privacy law that have been introduced over the years, including the American Privacy Rights Act and the American Data Privacy and Protection Act. I guess, Mr. Butler, I will start with you. Why is it so essential that we put reforms like these in place for consumers across the country?
Well, thank you for the question, Senator Klobuchar. I mean, we've seen what happens without federal leadership on privacy. Surveillance tools have become embedded in every website and app that we visit. And without a federal standard, companies really don't have the incentive to innovate on privacy protection. And a few big tech firms dominate the marketplace. So we're fueling harms to individuals, we're fueling harms to the market, and we're just allowing ourselves to be inundated by these surveillance and abusive data collection practices.
Thank you. And Ms. Goodloe, in your testimony, you highlight that there's broad consensus on many privacy principles across the 20 states that have them, both Democratic and Republican-led. I think Mr. Butler was mentioning how some of the early laws were weaker, there have been some improvements. What are the significant areas of bipartisan consensus that should be at the core of federal privacy legislation?
Thank you for the question. We see a lot of consensus on the right set of rights to give to consumers, both affirmative rights like the ability to access, correct, and delete their information, and on giving them rights to opt out of certain activities, including the sale of their data, profiling, and targeted advertising. I think there is consensus among most of these state privacy laws on that set of important issues. There's also a core set of obligations on companies. For controllers, it's things like asking for consent to process sensitive data. We have 17 states that require companies that are processing sensitive data to conduct privacy assessments, looking at the sensitive issues arising from that processing. And when it comes to processors, there is broad consensus that they have a separate set of rights to handle data on behalf of a controller pursuant to their instructions and to do so confidentially.
Okay, thank you. Mr. Levine, while at the FTC, you prosecuted unfair and deceptive acts and practices related to data privacy, as well as other privacy laws like those intended to protect young children. Despite your efforts to use every legal tool at your disposal to protect privacy, what gaps exist that are the most critical for Congress to fill through a comprehensive data privacy bill?
Well, thank you for the question, Senator. And as you alluded to in your remarks, we currently live under a privacy regime where companies have taken the position that they can basically do whatever they want so long as they disclose it in their privacy policy. Over the last 4 years at the FTC, we took a number of steps to try to push back against that. We told GoodRx they couldn't share sensitive medication information with Facebook, even if consumers clicked yes. We told BetterHelp it couldn't share with advertisers what mental health treatments people were seeking. We told Amazon Ring that its employees couldn't spy on people who were using their security cameras. But I can tell you, Senator, that every case we brought, when I would meet with counsel for those companies, they would tell us the same thing. Well, we put it in our privacy policy, so it's legal. I think our enforcement, the FTC's enforcement, and state enforcement and privacy enforcement would be far more effective with bright line rules on what companies can collect, how they can use it, and with whom it can be shared. Without that, you're going to continue to see a whack-a-mole approach that doesn't do enough to protect Americans' privacy.
Thank you. Very good. Mr. Thayer, I've long advocated for common sense rules to require the platforms to allow competing businesses the same access to the platform that they give themselves. Senator Blackburn has advocated for similar reforms in app store markets. But as you mentioned in your testimony, dominant platforms use privacy concerns as a pretext to avoid opening up their platforms to fair competition. How can interoperability requirements be implemented without putting user privacy at risk?
Thank you for the question, Senator, and also thank you for your work that you do on this, and also Senator Blackburn. You guys have been real champions on this issue, and I think it really does highlight the significant aspects and the concentration that this market involves, where we have basically 4 players, maybe 3 in some markets, or maybe even 2 in others, particularly in App Store, where you really you're at the behest of, or at the whim of whatever these companies want you to do. So you're basically stuck with whatever privacy policies that they decide on. And so So a good example of this is the stuff we're seeing at the DOJ with AAG Gail Slater at the helm, where she's been arguing on the remedies case, and the first argument that you got from Google was like, hey, you can't do this sharing arrangement because it'll violate privacy. But in reality, what they really care about is scale. They want to harbor the data. They don't really care about the privacy at all. It's really all a ruse.
Mm-hmm. And how can a strong federal privacy law help ensure that interoperability opens up digital markets to competition?
So I really point to the idea of a general statute versus a specific statute. And as you know, Senator, we have the antitrust laws are pretty broad, and so Section 5 of the FTC Act. Being able to designate exactly what we're interested in and target the actual acts that we're concerned with will help regulators down there. And this is precisely what Mr. Levine was alluding to when bringing that broader framework out. If we say interop is something that we all want to, that we all believe is something that could equal out a lot of, or balance out the scales, then it gives the regulator the ability to assess it in that way instead of using vague statutes.
Okay, last question, Mr. Martino. As you know, I was close friends of John McCain and miss him very much. In your written testimony, you say that businesses should not be responsible for the data privacy practices of other entities whose actions they cannot control, including the big tech platforms on which we know many businesses now have to rely to reach consumers. How can Congress ensure that responsibility is aligned properly with the entities best suited to protect consumer privacy?
Thank you, Senator Klobuchar. Well, I think the core principle we have here is that businesses need to have equivalent requirements, equivalent standards to protect data. There's a chart in my testimony that
We like charts. Huh?
Yeah, you like charts. I didn't make it real big, though. Sorry, but it shows some of the state law requirements for the big tech service providers, and you'll notice there are a couple red X's here on things that I think consumers would expect, and businesses like Main Street businesses would expect their service providers to do, which is provide data security. The state laws, for the most part, except for Colorado, I believe, don't require the big tech service providers to actually secure the data they're processing on behalf of businesses. They're only required to assist the controllers in their own data security and if they have their own breach. But there's a lack of parity there. Another place that I'll mention where there's a red X, and again, only I think Colorado and Connecticut have done this, but processors use lots of sub-processors or subcontractors, and they have requirements that any sub-processor they share the data with has to meet the same standards as the processor. But they don't give the Main Street business an opportunity to object to those sub-processors, those subcontractors. Only in 2 states that I'm aware of. And that is a big difference between, for example, what happens in Europe and what happens in the US. And so if there is, if you have a processor that you don't want to downstream pass on data to, think of some of the past breaches and privacy violations we've seen before. The Main Street business should have the ability to object to that. So we ask for the similar requirements that Main Street businesses have to live by.
Okay, thanks. And thank you. Sorry to go over.
No, thank you.
Samuel Levine, a Berkeley Law Fellow, spoke on the challenges surrounding privacy policies for major tech platforms. He began by highlighting the current state of privacy regulation, emphasizing that, without clear federal guidelines, tech companies are free to operate under minimal constraints. He shared that many companies argue they can do anything with user data as long as it is disclosed in their privacy policies. This disclosure defense means that, even when consumers are not fully aware of the implications, tech companies claim they are protected as long as the practices are mentioned somewhere in the policy. Levine noted the difficulty this creates for regulators and consumers alike. While the Federal Trade Commission, FTC, has taken action against certain privacy violations, such as halting the sharing of sensitive health data or stopping surveillance by smart cameras, these efforts are reactive and piecemeal. Companies, particularly large tech firms, continue to push the envelope, arguing that privacy policies give them the legal freedom to collect and share data without sufficient safeguards. This lack of clarity leaves consumers vulnerable, as they are often unaware of what data is being collected or how it's being used. He stressed the need for a federal law that would set bright-line rules, clear, firm standards on what companies can collect, how that data can be used, and to whom it can be shared. Without these, enforcement remains inconsistent, and tech companies remain largely unchecked. The existing situation, Levine argued, leads to a whack-a-mole approach to privacy enforcement, where new violations constantly arise without addressing the underlying structural issues. Levine also noted that such regulations should focus not just on the transparency of the privacy policies themselves, but also on ensuring these policies genuinely protect consumers. For instance, requiring companies to gain explicit consent before sharing sensitive data or setting clear limits on how long data can be stored would significantly enhance user privacy protection. Until a comprehensive federal framework is established, companies are incentivized to continue practices that benefit them at the expense of consumer trust and privacy. In summary, Levine's comments underscore the need for comprehensive, clear, and enforceable privacy regulations. With the current system, tech companies are often left to their own devices, interpreting privacy policies as broadly as they wish, and leaving consumers to navigate a confusing and often harmful landscape.